Imagine this. A company makes billions in profits but doesn't contribute a single rupee to social causes. Should they be held accountable? In India, they are. Companies are legally required to spend 2% of their profits on social development. But what happens if they don't? Are there consequences? How does the government ensure compliance? In this video, we'll dive deep into the legal obligations and enforcement of corporate social responsibility, CSR, under the Companies Act, 2013. Stick around till the end for some eye-opening real-life case studies that will show you how CSR is shaping India's future. What is CSR? CSR, or corporate social responsibility, is more than just a buzzword. It's a commitment by companies to give back to society. While many businesses voluntarily engage in CSR in India, it's a legal obligation under Section 135 of the Companies Act, 2013. But what exactly does CSR entail? Companies are required to invest in education and skill development to empower the next generation, poverty alleviation, to uplift the underprivileged healthcare and medical camps to ensure a healthier nation, environmental protection and sustainability to combat climate change, women empowerment and rural development to bridge the urban-rural divide. These initiatives are not just about charity, they're about creating a sustainable future for all. CSR is where corporate profits meet social impact. Legal obligations of CSR in India. Now let's get into the nitty-gritty of the law. Not all companies are required to comply with CSR laws, only those that meet the following criteria: a net worth of 500 crore rupees or more, an annual turnover of 1,000 crore rupees or more, a net profit of 5 crore rupees or more. If a company qualifies, it must form a CSR committee with at least 3 directors to oversee CSR activities, allocate at least 2% of their average net profits from the last 3 years to CSR projects, report CSR spending in their annual report and CSR policy document. But here's the catch. CSR funds cannot be used for business promotion or employee welfare. The goal is to create a tangible, positive impact on society, not to benefit the company directly. How CSR is enforced. So, how does the Indian government ensure that companies are actually following these rules? Enter the Ministry of Corporate Affairs, MCA, and the Registrar of Companies, ROC. They monitor CSR compliance through annual reports and CSR disclosures. Companies must publicly disclose their CSR spending and the projects they've funded. Transparency is key. Scrutiny and audits. The MCA can investigate companies suspected of violating CSR laws. No one can hide from the law. Penalties for non-compliance. If a company fails to spend the required CSR amount, they must explain why in their report. And if their explanation doesn't hold up, legal action could follow. The government is serious about ensuring that CSR isn't just a checkbox exercise, it's a responsibility that companies must take seriously. Penalties for non-compliance. What happens if a company decides to ignore its CSR obligations? The consequences are no joke. Under the Companies Amendment Act, 2019, if a company doesn't spend the required CSR amount, they must deposit the unspent funds into a government-managed CSR fund. Failure to do so can result in a fine of up to 1 crore rupees for the company, a fine of up to 2 lakh rupees for the responsible directors. In serious cases, legal proceedings may follow. These penalties ensure that CSR obligations are taken seriously. It's not just about avoiding fines. It's about making a real difference in society. In India, CSR is more than just a legal requirement. It's an opportunity for businesses to contribute to the greater good. What do you think about India's CSR laws? Should they be stricter, or do you think companies are doing enough? Let us know in the comments below. If you found this video informative, don't forget to like, share, and subscribe for more insights on CSR, NGOs, and legal compliance. Together, let's build a better future.